Hi, I'm Tamara Monosoff, founder of mominvented.com and my new mentoring and training website, tamaramonosoff.com. And if you have a product idea that's been percolating in your mind that you're thinking about bringing to market, then you most likely have asked yourself the question, how am I going to protect it and what do I need to know? And that's why I'm delighted to introduce you to my special guest and friend, John Merchant of J. Merchant Law, who is a business law attorney as well as an intellectual property attorney. Thank you so much for joining us, John.
It's great to be here. Thanks.
Today we're going to talk about something that I think there's confusion around this. It's called a provisional patent application because sometimes people think it's an actual application for a patent, which it is not. But I think it's one of the most useful tools available that I have used many times in the last decade. And I'm really excited that you're going to be able to bring some clarity about what the provisional application process is about and how inventors can benefit from it.
Yeah, well, I'm glad to clear some of the cloudiness up. There's a lot of discussion about provisional applications, and provisional applications can be very helpful to inventors, particularly small inventors, in getting the priority date for their invention. You know, we have a first-to-file system now in the United States, which means that the first person who files for a patent is in line to obtain first dibs on the patent rights. So regardless of when it was invented. So it's important to consider filing for patent protection as soon as you think you're able to do that. One way of doing that is through what's called a provisional patent application. Now, a provisional patent application relates only to utility-type patent applications. You can't file a provisional for a design patent. So the utility patent has to do with the function of a new thing, of an invention, and the design patent has to do with the aesthetic shape or the novel design of it. So you can file a provisional application for a utility application. It's basically an informal type of application. You're not required to put everything down that would be required in the formal way that a non-provisional would be required, but you have to describe everything that is part of your invention. You have to be able to adequately describe how to make and use it and all the aspects that you think are important and need to be patented. So
I think one of the
you have to be very...
I'm sorry. I think one of the things that was so amazing about a provisional patent application is that it buys you a year to really get all your ducks in a row and to figure out
That's right.
If you do choose to file an actual utility patent, then you have had a year to really figure out all the different aspects of your product so that you have a much more powerful utility patent in the end. Would you agree with that?
Yes. Yeah, I would say that's true. I mean, provisional applications are basically placeholders. They provide you with a filing date. And you can file actually multiple provisional applications and capture them within a year of filing the first one. You can capture all that's in the various provisionals that you filed with one regular or non-provisional patent application. The thing to remember about a provisional application is it's never read. It's not something examined. It's not something the examiner picks up, examines, and does the back and forth thing that you would otherwise do with a non-provisional. It is simply a placeholder, but it provides the basis upon which you can file a non-provisional application and eventually receive patent rights. So it's an important tool.
I think two of the aspects of the provisional patent application that I find as a business person to be the most useful is that when you file, and correct me if I'm wrong, but when you file a provisional patent application, you can put patent pending on your product package. Is that right?
That is correct.
And
once you file the provisional patent application, you can put patent pending.
And so that's great. And then my favorite part of a provisional patent application, if we can get excited about provisional patent applications, is that no one can see what you have actually applied for. as a business person, when you're trying to get to market, one of the hardest things when you've actually filed a patent is it becomes public. Then everybody, your competitors, can actually check and see what it is that you have filed and what you have patented. And what I love about the provisional patent application is it actually buys you time to have your product out there, potentially, if you've brought it to market already, and no one can see what actually you are claiming to patent. Is that accurate?
Well, that's accurate. It's not examined, and if you don't take advantage of the provisional by filing a non-provisional within a year, it just basically disappears. No one's going to. It's not published, so it's not going to get out there. And if you want to maintain your idea, your invention as a trade secret or something that's basically secret, you can do that and still file a provisional patent application.
Yeah, it's an incredibly useful tool, and I really appreciate you spelling out what it means and how inventors can take advantage of it. Thanks so much, John.
Great, thanks.
I hope you'll join us for our next segment with John, where John is going to talk to us about what a trademark does and what it protects and how are they useful, and most importantly, what's the difference between a TM, a trademark symbol, and an R, a registered symbol. John's going to bring us up to speed in our next segment. Thanks so much for checking in with us. Talk soon.